Okay, let's talk about the lowdown on dispute resolution, resolving client conflicts with mediation. So the most common thing we hear from freelancers that are in a bit of a pickle is, I want to avoid anything legal. And that's completely understandable. The legal system is unfamiliar to most people. It is scary and it is very expensive. Now, obviously, there are insurance policies designed to do a lot of the heavy lifting for you, like sourcing and covering the cost of legal representation. But not every freelancer has insurance. Not every freelancer wants to use their insurance, and sometimes insurers might even suggest dispute resolution. So let's talk about what dispute resolution is and why it's considered such a good option for freelancers. So resolution methods like mediation are more relaxed, they are more informal, and they are a much cheaper approach to solving disputes. Alongside an independent third party, known as a mediator, who oversees the discussion, you and your client come together to discuss the issue. After all, talking through a problem is so much better than lengthy legal battles where the outcome is in the hands of the justice system. So the mediator's role is to facilitate negotiations, and as they're impartial, they won't advise on outcomes, but they will assist both sides in reaching an agreement. It's a very active, very iterative process for both you and your client. Now, mediation is a quicker process than other legal options, which is part of its appeal. For disputes that are resolved, agreements are usually reached within just one session, and the success rate is very high. And once a conclusion has been reached, the mediator drafts what's known as a settlement agreement, and this details what was agreed to between both parties. So you can expect it to include things like a schedule of the dispute, what was the dispute about, what outcome has been agreed, and who is paying what money to who, an agreement not to sue, and no admission of being wrong. The agreement is not an admission of liability for either party. Ideally, mediation just helps you draw a line under the conflict whilst avoiding court fees and legal overheads. And because the outcome is reached by both parties and not a judge or jury who determines the outcome, there may be an element of compromise involved, but this is not uncommon when conflicts have reached the stage where mediation is necessary and legal action is potentially looming. And of course, the alternative is that you take the fight to court. However, this is at the expense of lengthy court proceedings, no guarantee that your outcome will be favourable, and significantly more costs involved. So do you actually need to go through the mediation process? Well, courts are increasingly expecting you to have tried mediation before anything else, and you might even find that mediation is a contractual requirement within your client contract. And if you're unsure what your client contract states, check out the dispute resolution section, because it will say something like, matters will be resolved through mediation with the assistance of a mediator. And earlier I mentioned that some insurers also suggest mediation. Well, each situation is assessed individually, but if the insurer thinks mediation is suitable, then they will highlight this. They'll send an invitation to your client asking if they wish to engage in the mediation process, giving them 14 days to respond. And if the client declines and formal legal action is required, well, guess what? The court will look more favourably on you because you've been open to reaching a conclusion. So if mediation is something you'd like to offer your client, being insured opens up your options, either in terms of having your policy assist you in the event of a valid claim or getting access to the right people to help you. Otherwise, you can reach out to a mediator independently to help facilitate conversations between you and your client.